Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Today we have an interesting little case from the Third Circuit, the Third United States Circuit Court of Appeals, that deals with arbitration. Now normally when there is an arbitration case, it arises in the context of a dispute between two businesses. And that's because the parties have agreed that they wish to settle their disputes through arbitration. Those cases usually involve there's a problem with a contract term, or there's some question about whether or not one side or the other has breached its agreement. And as a result, it is often quicker and cheaper to go through arbitration for the two businesses. They will sit down and they will make their case to the arbitration panel. And an arbitration panel usually has three people. The person on the plaintiff side picks one, the person on the defense side picks one, and then those two get together and they pick a third arbitrator, usually from a list approved by everybody, that will then serve as the panel that will hear the case. And then they present the evidence, and it's not subject to the rules of evidence in a court. You don't have to have formal testimony. One side can come in and they can agree to simply present the case in narrative form with documents. It's a lot less formal, and it's also a lot quicker and less expensive. Now, you have to pay the arbitrator something, and you have to pay the arbitration service something, but generally speaking, those are less than you would if you had to do multiple depositions and pay a lawyer $500 an hour to do those depositions, and then pay the court reporter $600 for typing out the deposition, and if you have experts, it's even worse. So in a situation like that, arbitration makes a lot of sense. The other place that it tends to show up a lot is in union issues. And unions, when they negotiate their contract with the business, will usually put in an arbitration clause because arbitration tends to favor, in many respects, the working guy when it's dealing with a big company. That just seems to be the way it goes. Doesn't always work out that way, but it does work out that way quite a bit. And in this particular case, that's exactly what happens. It works out very much to the benefit of the union, and then the business says, hey, wait a minute, let's go to court and ask the court to essentially vacate this award. And that's what happened. The district court vacated the award. So let's take a look at the opinion. Here we have the International Brotherhood of Teamsters, Local 469, appealing a decision vacating an arbitration award. And in this case, what happens is this: courts are restricted in reviewing the decision of an arbitrator resolving a labor dispute under a collective bargaining agreement, but that deference is not unlimited. Here, the arbitrator evinced a manifest disregard for the underlying collective bargaining agreement when she held that a grievance by the union was timely filed. So we will affirm the district court's judgment. Again, Third Circuit doesn't bury the lead here. They'll tell you up front, you lost. And then they'll explain why. So the appellee, Stonemore Incorporated, that's the company that won at the district court and lost before the arbitrator, they operate cemeteries. And the maintenance workers at two of its cemeteries unionized and certified the union as their bargaining representative. The union then entered into negotiations for an agreement. Those parties came to a tentative agreement. The agreement which they signed and through which they intended to be legally bound said that it was to remain tentative until ratified by a majority of the cemetery maintenance employees. It provided a grievance procedure giving the union 10 days to write Stonemore about a disagreement as to the interpretation. The agreement emphasized that time is of the essence in handling disputes, and if the parties could not settle a dispute, it would be subject to binding arbitration. So to make some sense here, we're going to do a timeline, and the tentative deal is reached and it's submitted for union ratification prior to October 5th of 2020. On October 5th of 2020, the agreement is ratified by the union. Now, according to the plain language of the agreement, that's when the agreement takes effect. Now, there's a provision in the union agreement that contained a wage increase effective every October 1st. Union members expected the pay raise in the first year of the agreement. Now, since the agreement wasn't ratified until after October 1st, the business took the position that, no, you don't get one this year, you get one next October 1st. Well, the union members expected it, and the business didn't plan on giving it, and as a result, a dispute arose. So here's how that all played out. On October 30th, 2020, the union raise was not in the paychecks. The members were upset, and they notified the business in writing that they had a dispute. And the business said, hey, guess what? You can take it up on a grievance. At the same time, they are still trying to negotiate to get a final written agreement done. And in November of 2020, the union sent a final agreement spelling out the wage provision, and on December 29th, 2020, the parties executed the final agreement. And then, in January of 2020, they filed their grievance saying, hey, we should have gotten that raise on October 1st. And the business says, you are too late in filing this grievance. But because they submit everything to binding arbitration, they go into arbitration. So the arbitrator not only gets to decide what the substantive issue is, do they get the raise or not, the arbitrator also has the right to determine whether the grievance is even timely filed or not. And she decides that it is timely filed and fines for the union workers. On timeliness, she reasoned that the contested provisions had been unresolved from the ratification from October 5th until execution on December 29th, and that January 5th was within 10 days of the actual final agreement being signed. But Stonemore did not include the originally agreed upon wage provision in any of its cleaned up drafts after ratification. It was not included again until the union's November 2020 draft. By the arbitrator's lights, it was reasonable that the union would ensure that the originally agreed upon language was incorporated in the final agreement before it filed a grievance. The arbitrator continued, moreover, the union was not required to file a grievance while the parties were continuing to clarify and negotiate the provisions of the agreement until the agreement was fully executed. And she found the agreement was executed on 29th, and the union filed its grievance less than 10 days later. So Stonemore, the business, petitioned the district court to vacate the award. And the court granted that petition, holding that the award had no basis in the underlying agreement. The court reasoned that the agreement was enforceable as soon as it was ratified by the union members on October 5th, 2020, and that the grievance provision was triggered by at least October 30th when the paychecks arrived without a salary increase. And as a result, the decision of the arbitrator was contrary to the plain meaning of the agreement. So under the Federal Arbitration Act, the district court can overturn an award of an arbitrator only if the award was procured by corruption, if the arbitrators were corrupt or guilty of misconduct, or if the arbitrators exceeded their powers or so imperfectly executed them that a mutual, final, and definite award upon the subject was not made. An arbitrator exceeds her powers if her award fails to draw its essence from the collective bargaining agreement, which is sort of what you'd expect. It's a steep climb to vacate an arbitration award, but they do reverse when the arbitrator rewrites the contract. And here the arbitrator did just that. The agreement by its terms became final once it was ratified by the majority on October 5th. Certainly by the end of October, when the agreement didn't provide for the raise, then the union knew that it had a problem and it had 10 days to file the grievance. That tracks the language of the agreement. There's no reasonableness exception to the grievance procedure in the agreement, and it explicitly said that time was of the essence, and the arbitrator's holding was not based on anything in the agreement. Instead, the arbitrator simply asserted the union was not required to file a grievance while they were continuing to negotiate. And again, that's pretty clear that it's contrary to the plain language of the agreement. And the Third Circuit here does what you would expect a court to do. Read the agreement and base your decision on the agreement itself. And since the agreement said it took effect as soon as it was ratified, even though it wasn't reduced to writing at that point, not in the final version, that was the date that controlled, according to the Third Circuit. It is fairly rare to see an award by an arbitrator overturned by a district court. As long as there is almost any basis at all for the award, the arbitrators are pretty much given free rein. This has been one of the great criticisms of arbitration awards and arbitration in general. In a situation where you have a union, which is effectively a business, going up against another business, the parties have equal bargaining power and they have the right to submit this to arbitration if they want. But for example, when you buy a new car, when you buy a new cell phone or go get new cell phone service, a lot of times what happens in that scenario is you have a consumer dealing with a multi-million-dollar company and the bargaining power is completely juxtaposed. There have been a lot of opportunities that Congress has had to ameliorate the unfairness that's built into the Arbitration Act, and they haven't done it. And as a result, courts continue to interpret it according to the rules set down in the Arbitration Act itself. So my advice to clients always is to never agree to an arbitration agreement. Unless you are a business, it is not going to work out in your favor. So that's what I have for you today. If you have any comments, drop them in the comments down below. Questions, put them there too, or you can send them to me by email. One of the things that makes the world a better place is when you have the opportunity, you do something nice for someone. I hope that today you get an opportunity to do something nice for someone. I'm taking my wife to lunch. We're stopping by the bank. We're fixing a CD. And then we're going about our business for the rest of the afternoon. So thank you so much for being here. After you've done a kindness for someone, come on back down here tomorrow. Join me at the beach, and we'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.